115634, State of Kansas v. Blancet, or Blancet.
I keep wanting to say Kate Blanchett, but it is Lindsay Blancet. Lindsay Blancet. And Michelle Davis appearing on behalf of the appellant. And Mayor, please reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Ms. Blancet, a woman in her mid-30s, had two fairly young children, 9 and 10 years old, divorced. She suffered a psychotic, manic episode that she characterized as losing her mind, and as a result, she caused the death of her son. She started having these fears and paranoia several weeks before the incident. She believed her ex-husband was abusing the son, and this actually happened on a Sunday. On a Friday, she went to social services and also talked to her church people about taking her children. She knew she was losing it. That Saturday, she went to a friend's house. She was so afraid to be in her own house because she was afraid they were going to come and kill and or hurt her and her children. So she's at the friend's house. The friend testified that he has to reassure her that they're walking around the house, locking the doors and the windows, and he has to show her that there's nobody in the house. And then that Sunday, she went back to her own house because she didn't have any choice. The ex-husband was willing to take the kids on Monday, and that was the plan. And then she was going to go to mental health and maybe commit herself. And then this incident happened Sunday where after the kids went to bed, her sense of terror and dread just increased. She heard noises. She heard a noise in her son's room. She had images of her son's arm being cut off and her son being tortured. And she thought that she would be killed and she wouldn't be able to protect him. And so she's walking around the house with a knife. At some point, she's in her son's room. She compared her terror to a lion that's catching up with her. And then at some point, the lion's getting closer and closer, and then that's it. At that point, she decided, she said in an instant that she needed to kill her son. She needed to send him to heaven. And she did. She stabbed her son with a knife several times. Her daughter approached the room, and she said she came out of this trance and she realized what she had done. And she called 911, and they responded, and the wounds were fatal. And so the son was pronounced dead at the scene. The main issue in this case is in the mid-90s, Kansas did away with insanity defense. And that type of affirmative defense says despite the commission of the elements of the crime, that the defendant could not appreciate the wrongfulness of her conduct or could not conform her conduct to the law. It was not volitional. So Kansas doesn't have that affirmative defense anymore. So basically, a defendant can introduce evidence of mental illness, mental disease, or defect to show that she lacked the mental state that's required for the commission of the crime. And so the issue in this case is the district court's instructions to the jury prevented the jury from considering her mental illness as it related to her ability to premeditate.
What is the? Oh no, go ahead.
You can go first.
No, what is the culpable mental state for premeditation?
The culpable mental state for first-degree premeditated murder would be intentional killing with premeditation. Killing done intentionally and with premeditation. So there would be the intent to kill, which is also the culpable mental state for second-degree murder. And then with first-degree murder, the difference is the additional requirement of premeditation.
Is there a separate culpable mental state for premeditation, or is it a part of the intentional act?
Well, the way this court has defined it, this court has distinguished it as that it's a reflection or deliberation, that it's not done on impulse. I believe that's the way this court has distinguished premeditation, that it's a killing without reflection cannot be premeditated, an impulsive killing. So that's the way this court has distinguished reflection as a mental state.
It's essential to your argument, isn't it, that we say that it is part of the mental state or the mens rea? Because otherwise there's no defense at all. I think the state's position all along has been premeditation isn't part of the mens rea.
Right.
Mm-hmm.
And so it's an essential part of your argument that we would say, yes, it is.
Well, yes, it is, but it doesn't really matter whether you do it under the statute or not, because, I mean, there's an argument to be made for that. The state somehow, I just don't
know what
understand.
that meant.
Well, I don't understand the state's argument here, because the state's argument is if you can't, basically saying a defendant can't put on evidence to defend against the element of premeditation if it's not a quote unquote
That's the
culpable
way-
mental state under the statute. And so that contradicts this court's decision in Bethel, which says that this mental disease or defect statute doesn't prevent a defendant from putting on evidence to defend against the elements of the crime. If you carry the state's argument to its end game, that's what you're going to get. You're going to say a defendant can't put on evidence to negate premeditation because it's not quote unquote a culpable mental state. I don't think there's a difference between mental state and culpable mental state, because when this statute was passed, it talked about mental state. It was 223220 was the old statute, and it says the defendant lacked the mental state required as an element of the offense. Now, there's other statutes still in effect that talk about mental state. There's 223221 talks about mental state. 223219 in the context of mental disease and defect, that's the notice requirement, and it still talks about mental state. So in the context of mental disease or defect, even though the other statute, which is 215209, added the word culpable, the legislature uses both terms interchangeably in regard to this defense. The legislature didn't draw any distinction between mental state and culpable mental state. Both of those terms are used in regard to this defense. And in addition, the state tries to argue that because the statute that came in 21, that talks about the new statute, that talks about the different types of mental states, being reckless, intentional, and as if those are the only kind of mental states that you can have. But there's nothing in the statute that says that those are the only mental states that are allowed. And let me get that statute number for you. It's 215202. It just says that a mental state's an essential element of every crime. And if crime needs a mental state and it's not provided in the statute, then use one of these three choices. But it doesn't say you.
It's non-exclusive.
It's not. Yeah. It doesn't say you have to use one. It says the state may establish this by this and use one of these if the statute doesn't provide for it. There's nothing that says the legislature can't put in another mental state into a crime if it wants to.
Ms. Davis, I'm having talked about what the state's arguing. I want to try to better understand what you're arguing.
Okay.
What you're really taking issue with here.
Mm-hmm.
First of all, we're hampered a little bit, of course, by the fact that there was no objection below to either the instruction number 6, the wording of instruction number 6, or to the jury, the response to the jury when they came out with their question during deliberation, or for that matter to the judge deciding not to give a second special question to the jury on its verdict form having to do with intentional second degree and the reason for finding not guilty on that crime separate and apart from not guilty on first degree. Mm-hmm. It seems to me that what you're arguing is that all three of these things combined to prevent the jury from having a true opportunity to consider second degree. Is that what you're arguing? It's about whether they had the ability to understand that they could convict of second degree?
Right, because the initial instruction said not criminally responsible because it says, well, let me back up, because the first sentence says only consider this evidence in determining if the defendant had the culpable mental state. And then the jury comes back and asks the question and says, in regard to mental defect, what does culpable mean? And then the judge comes back and says, you're only to consider intent. So the judge is telling the jury only to consider this evidence in regard to intent, if you put those together. And then the instruction later goes on, not criminally responsible if because of mental defect, lack premeditation and intent to kill, but the instruction doesn't say. It should say not criminally responsible for first degree murder if you lack the premeditation and the intent.
And then you needed a separate instruction on second degree?
Well,
is that what you're saying? I mean, that's what I'm trying to understand. What was this supposed to look like?
That would be more complete. That would be a more complete instruction, right? And the judge would say she's not criminally responsible for, right. It would be to break up the premeditation and the intent. It was like the way what the judge conveyed to the jury is, it's all just goes to first degree murder. And the judge took that away from the jury to say, when the judge said, only consider, the only culpable mental state is intentionally. That's it.
For first and second.
No, well, no, the jury said, in the context of mental disease or defect, what does culpable mean? And the judge,
It was more cryptic than that. It was just culpable question mark or something.
but it was in regard to jury
Culpable.
instruction number 6, which is the mental disease or defect instruction, right? That's the
It says
instruction I just,
definition of culpable question mark refer to instruction number 6.
right, and that's the instruction where the judge told them, you can only consider this evidence in determining whether the defendant had the culpable mental state required for the crime. So the jury's saying, what do we consider in regard to the culpable mental state? And it's a good question, because as the prosecutor pointed out, the instruction's telling the jury what to do if they find no premeditation and intent, but it doesn't tell them what to do if they find intent but not premeditation.
Right, which the prosecutor is the one who had pointed that out to the judge, which was the catalyst for the judge saying, I'm going to give this extra special question so they can tease it out better.
Right.
And then decided, well, we don't need that information from the jury, which I don't think is wrong. I think that's right. Once you had the verdict, you would know what they did. But it's not what they can tell from a verdict. It's what the jury could tell from the instructions and the answer to the question, is your point.
Right.
Is that right?
Right.
I'm just having trouble following what exactly it is that went wrong here in your view.
Right. Right. That's what went wrong, is that everything about mental disease or defect was focused just on premeditation and intent. It wasn't anything about what do we do if we don't apply it to premeditation.
So your complaint, if we can sum up again, is that the jury was not given what you consider a fair opportunity to convict on second-degree intentional as opposed to first-degree pre-med.
Right, because the judge, in the judge's response to the jury regarding culpable mental state in the mental disease or defect instruction, the judge told them the only culpable mental state for first and second-degree murder is intentionally.
So that's a problem with the response to the jury question.
Right,
Did you
but
have a problem before that with what the instruction said?
Right, because it also ties back to
Is that a yes?
Yes,
Right, it's a
yes,
yes.
yes.
Okay.
It also ties back to the mental disease or defect instruction where it says that instruction is erroneous given the judge's response to the jury.
Well, you're saying because it conjoined premeditation and intent, which would negate applying the culpable mental state just to premeditation.
Right. So when the instruction
Right.
says, right.
Is that what your argument was?
Right, and when the instruction says the defendant is not criminally responsible, well, it's not, you're not criminally responsible, you haven't committed a crime. The defendant hasn't committed a crime if because of mental disease or defect she lacked premeditation and intent to kill, or the awareness to do the ag assault. There's nothing in there about second-degree murder. What is the defendant responsible for if she lacked premeditation? But she had the intent to kill. There's no guidance to the jury on that.
So you're,
Other than the definitions of the, I mean, they do have two elements instructions as well that had footnotes defining premeditation and intent, didn't they?
Right, and that's why I think the jury came back and asked the question.
But didn't that give the jury quite a bit of information about what was required for each crime and how to define those two terms?
Right, but then what they're telling the jury is don't consider that evidence for that purpose. It's exactly what the prosecutor's arguing to you today. The prosecutor's arguing to you this evidence should not be considered in regard to premeditation because it's not a culpable mental state. That's what the jury was told.
This kind of goes to the harmlessness, but also just even to whether there was error, I think. And that is, help me understand how someone would have the mental capacity to premeditate but not to intend.
You're right.
How someone would have the mental capacity to pretend it.
I mean,
think
you're trying to
right.
split them, and I'm just trying to see as a practical matter how there could be a difference in the evidence.
Actually, I don't want to split them. I'm actually agreeing with you. I don't think you can parse them out. That's why I don't think the prosecutor's, what he's advocating is going to work. Because I think they're just too intertwined.
But then why, if second degree is dependent on intent, you wouldn't have that either.
Well, no. The difference would be that an intentional killing that was done instantaneously. There was evidence where she said, they asked her, when did you intend to kill your son? And she said, instantly, in the moment, right before she did.
And I guess to clarify, so the answer is that you can have a successful mental disease or defect to first-degree murder, but not to second degree.
You could under some circumstances.
And what are those circumstances?
Yeah,
I'm having trouble parsing
right.
that.
I mean, the extreme case would be that you killed a human being, but you were mentally ill and you thought you were killing an animal. I mean, that would be or you know, it would have to be somebody who was extremely mentally ill, that was so mentally ill that they didn't even appreciate what they were doing. I mean, it's
Well, that would
theoretically
go
possible.
to, I still don't see how that's consistent with my question.
Mm-hmm.
Is that goes to the intent, the overall intent
Mm-hmm.
in both first degree and second degree. How can you have a successful or an argument that mental disease or defect would apply to a first degree murder, but not to, could a jury find that and then find them guilty of second degree murder?
Right, so the
potentially?
guilty of second degree would be that because of their mental illness, they did not premeditate the crime. That would be, and that
But
was,
they could form the intent to kill.
right, and that was really the only defense in this case. I mean, that was her defense, is that she was overcome with terror, and that's what this case
That
was all
didn't
about.
go.
That's what,
That didn't go to the second degree. Also,
right.
it did not.
I guess I'm not understanding your question.
My question is, again, is the mental disease or defect went to second degree murder too, didn't it?
Right. But I mean, in this case, that was really the contested issue because both of the experts said that she intended to kill. So really the reason this case went to trial was really over the idea of premeditation or not. Did she premeditate this, or was this an instantaneous crime?
Well, that's not the focus of the, excuse me.
I was going to say, and the judge, in response to the jury's question, in your view, effectively said you don't need to worry about premeditation. You only need to worry about intention. And that is what would be covered by mental disease or defect. Is that right?
The judge just said the culpable mental state for first and second degree murder is intentionally. The jury was told to only consider the evidence of her mental disease or defect as it related to the culpable mental state.
And your point is the real issue was premeditation. And the
Yes.
judge, in effect, is telling the jury, as a matter of law,
Don't consider the evidence
mental disease or
of her
defect
mental disease
to
or
go to
defect
premeditation. It's
because
just not going to work.
intentionally, right, because intentionally is the only culpable mental state for first and second degree murder. That's what the judge told
So
them.
what should the instruction have said?
Well, the instruction should have given the
What
jury.
is the culpable mental state for premeditation? That was my first question. I still don't hear an answer.
Well, it's not the culpable mental state for premeditation. It's the culpable mental state for first degree murder is the way that it needs to be.
You're parsing it out. The distinction is premeditation versus not premeditation between the two crimes. What is the culpable mental state for first degree murder?
And first degree murder is premeditation, a premeditated intent to kill. Intent to kill with killed intentionally and with premeditation. It's both. It's both. It's both. This court has said that premeditation is a mental state, is the mental state for first degree murder. And this court has said that.
It's a subset of intentionally. It's premeditated intent. Is the culpable
Right, because
mental state.
that's what you distinguish first degree from second degree from. I mean, the classifications of murder are defined by the defendant's subjective mental state. It looks like I'm out of time. So
even if the jury bought, in your view, the idea of a mental disease or defect, the judge is telling him that is irrelevant to the question of premeditation, which
Right.
is an element of first degree murder.
right, right.
All right. Any more questions? I think I cut you off, Justice
No, I'm
Snyder.
okay. I think I got an answer.
All right, thank you, counsel.
May it please the court, I'm Kerwin L. Spencer, the county attorney for Sumner County, here on behalf of the state of Kansas today, and accompanied by Mitchell Spencer, the assistant county attorney for Sumner County.
Good morning, counsel.
Thank you.
Could we focus right away on your consistent argument throughout the case that premeditation is not a culpable mental state? Do you have any support for that argument other than its absence from the statute cited by your opposing counsel that lists intentionally, knowingly, and recklessly as culpable mental states? Is there anything beyond the fact that it's absent from that statute that you rely upon?
Well, it's not only culpable mental states are classified according to relative degrees from highest to lowest as intentionally, knowingly, and recklessly.
Right.
Those are the three. It's listed right there. And then sub G provides that if the definition of a crime prescribes a culpable mental state with regard to a particular element or elements of that crime, the prescribed culpable mental state shall be required only as to that specified element or elements, and a culpable mental state shall not be required as to any other element of the crime unless otherwise provided. So, and then you look at the first-degree murder statute. It provides that it'll be unlawful to kill a human being, intentionally kill a human being
With premeditation.
with premeditation.
Right.
So it doesn't say with intentional premeditation. So that's why I have consistently used the argument that
So did the passage of that statute, and I forget the year now, but the passage of that statute listing the culpable mental state,
yes.
did it alter Kansas law?
Yes, it certainly, in my opinion, rendered the language that the court followed from the State v. White case some 6 or 7 years earlier, that you consider the mental illness as having an effect on premeditation, that rendered that not to be good law anymore.
Well, it'd be more than white. It'd be a legion of cases in Kansas that have treated premeditation like a culpable mental state, like as a mens rea for the crime, as a part of that element.
Well,
So are all those cases just bad law now? Or old law, outdated law?
to the
Superseded law?
extent that we still clearly have to prove premeditation as an element of the crime. So what you would deal with is...
But it's not mens rea. In your view, it's not mens rea. It's
Right.
something else. It's some
Right.
other animal. It's timing or timing, really, more than anything. Was there enough time
An
for the person
opportunity
to
to-
think about it?
an opportunity to reflect.
Right.
Yes.
So in your view, it's no longer mens rea, and all of our cases that went before passage of that statute are just no longer good law.
Well, to the extent that they deal with just premeditation as being subject to a mental defect, yes. But it doesn't eliminate the fact that they're all still good law on what we have to show
Yeah,
to
I
show that there was premeditation.
Okay, thank you.
So and also on this case, the standard for review, only the state objected to the instruction. So the defense did not object to the instructions. So the standard of review is a clear error analysis. One, whether the instructions misstated the law, and if there's no misstatement, that ends the analysis and the state wins on that issue. Only if error is found do we proceed to further in our analysis. And then the defendant has the burden of showing that but for the error, the jury would have returned a different verdict. That burden never shifts to the state since the defendant did not object to the instructions as given. The only objection by the defense counsel was to the alternate verdict form that the trial court decided not to use. So in our conference, the defense counsel objected to pointing out that if you find the defendant not guilty of first-degree murder because of inability to premeditate due to mental error, then did you find that second-degree murder, he was found guilty of second-degree murder because of that defect? Defense counsel objected to that. Upon reflection then, before that was actually given, the court took that out and gave just the verdict form that was subsequently used and signed off on in the record. So-
Mr. Spencer,
Yes,
on that, on the verdict form,
Yes.
when the judge was contemplating adding that second special question,
yes.
where was it going to be? Do you know? I have a copy of the verdict form as it was ultimately used, but
Well,
what
it
was
would,
it going to look like had it been included?
on the same form, underneath, if I could find my verdict form, I think I
It's
had,
page 88 of the record, volume 2, if that helps you. That's the actual signed one.
right,
So I was just trying to understand where that special question was going to be. Was second degree intentional going to be on a different page or something, and then
No,
have
it
its own
was-
special question, or what was it?
no, it was, not on a separate page, it was, right, I can't find that. The verdict form, this is the instructions.
Yeah, I'm more curious about what the verdict form would look like if that second question had been included. I just didn't understand that from the passage in the transcript.
And we could look at the transcript of the instructions as, the instruction conference as well, but where it
Right.
says that, okay, they signed off on the first verdict of, we find the defendant guilty of the crime of murder in the first degree.
Right.
Then there was,
The option of guilty of the lesser
right.
included, and then the option of not guilty, and then the
right,
special
it
question.
was, if your verdict was not guilty, answer the following special question, and then there were two special questions. The one as given there, which is, and then right below that, which would have been, on the next page before we get to the verdict for the aggravated assault, was the second special question of if you find the defendant was guilty of second-degree murder solely because the defendant was did not have premeditation. I forget the exact language that.
So it
the
looks
judge
like,
used.
to me, from looking at page 127 and 28 of the transcript of the instructions conference,
Mhm.
and I'm sorry, I don't know the volume number on that, that the second special question would actually have been listed first.
No, I
No?
believe the second
When he
special
reads
question
them?
would have been listed second.
Because the one that was not given, let's call it that rather than
Right.
first and second.
Would have
It
been
looks-
second.
It looks to me like the one that was ultimately given is the one he lists as second when he's discussing it. Not because it was the second one thought of, but just because it would have been listed second. Anyway, it was never written out anywhere, was it? It was just discussed? Or is there
No, it
someplace in
was
the
writ-
record I can look
It
for?
was written out.
Okay,
I'm not sure that it was included in the record on appeal, but I know it was written out because the verdict form was not given to the jury the first day.
right,
And before the verdict form was given to the jury, the judge decided that he should eliminate that and use the one that he used.
right,
So
okay.
I know it was written out at some point in time, or he would not have had one that was
But it
just
wasn't
negligently
proposed
not
by
passed
either
on.
party, so it doesn't apply. I mean, it doesn't appear in either of the
Right.
parties proposed.
It was not proposed by either of the parties, but that one that was not used was objected to by Mr. Brown, and
Right.
that's the only thing that Mr. Brown objected to.
I'm aware of that.
as-
It was okay with you because you thought it was consistent with what was in the instructions.
That's, yes,
That was your expressed opinion.
But-
so.
yes. That was acknowledging the judge's wisdom in deciding that premeditation was,
I understand. You reserved your objection to the
right,
whole
exactly.
shooting match, but you were willing to give up on the
Well,
second
if
special
you
question.
go with that premeditation as being a mental defect or subject to mental illness such that he be found not guilty, then I thought that was consistent.
So actually, to the degree your opponent, and this is kind of where we're getting down to, to the degree your opponent thinks that the omission of that extra special question, whether it was going to be first or second, that's neither here nor there for purposes of this question, to the degree that that's her complaint, that that
Yes.
second special question should have been included,
Yes,
you would actually agree, yes, that second special question made the verdict form more consistent with the judge's instructions.
Yes, but I respect the judge's desire to not give us an issue on appeal. And if you go with what the defense attorney wants, then it's a clear error analysis. Whereas if you don't go with what the defense attorney wants, then the state's got the burden on appeal to show that the decision would have been different. Whereas the analysis for who maintains the error as being prejudicial on this issue stays with the appellant throughout these entire proceedings on the issue of whether or not this is a harmless error analysis or not. The instructions as...
I see what you're saying. The fact that the defense had objected to it,
Right.
the judge was trying to eliminate an issue on appeal. If it isn't really necessary, then I'm not going to give it because it gives them one less issue to appeal. I understand what you're saying.
Yes.
Okay. But you personally thought it was more consistent to give the second special
Well,
question.
if we're dealing with my personal opinion is neither one of them should be there as to the issue of premeditation.
I know that, but we're going to assume we're ruling against you on that point for purposes of argument right this minute. The bottom line is you thought the additional special question would have been helpful in terms of being consistent with the judge's instruction.
It would have... Yes.
Thank you.
Okay. Well, I see I've got about 3.5 minutes left, and there is a whole other issue to deal with, but part of that argument deals with, whereas the defendant, the appellant has the burden throughout the entire proceedings of showing that their jury would have come to a different conclusion but for the alleged error on the instructions. On the second part, claiming that there was error by the prosecutor, me, in the closing argument, and in mixing up the acting intentionally and with premeditation. We can look at State v. Marks, 297 Kansas 131, 2013 case. The appellate court should review the presence of these facts in evaluating whether the appellant can firmly convince this court that but for the trial court's answer to the jury's questions that a different verdict would have resulted. And these same things deal with for you to evaluate whether or not there's any cumulative error, because if the evidence is overwhelming, cumulative error is never found. One, here the nature of the weapon used was that two weapons were used. Defendant abandoned the rock and turned to the more deadly knife to accomplish her goal of killing her son. Two, the lack of provocation by the victim could not be more clear. He was sleeping when she first struck him with the rock. Three, the defendant's conduct before and after the killing was she carried two weapons into the bedroom. She picked out a very large rock and a very sharp knife, as you can tell by the photos. Like an 8-pound rock, it's my recollection. Threats and declaration of the defendants before and during the occurrence include when her son woke up and said, "Mommy, stop." She stabbed him 7 times, and she told him that this was the only way to make sure that he got to heaven. The dealing of lethal blows after the victim was rendered helpless is shown by the 7 stab wounds to the chest in the autopsy. And she told Detective Wilson that she checked to see if he was breathing or if his heart was broken after the 7 stab wounds, and she didn't detect it. For a little bit there was something, and then she talked about there be a gurgling, and they talked about that being a death rattle, and that being after the 7 stab wounds, and then he passed away before the ambulance and so forth got there. So that shows that the evidence was overwhelming. Now, the issue of the rock, there's nothing in the record that it indicated that that she picked up the rock to use to go on patrol as a defensive weapon. I thought maybe there might have been something in one of either Dr. Steffens that I misremembered when the judge corrected me on that, but I looked at Dr. Steffens' statement again, and there's nothing about using the rock to go on patrol and hope to ward off intruders. There is statements to Dr. Steffen, to the other Dr. Dom as well, not to Detective Wilson, but to those specialists on the going on patrol with a knife, which she armed herself with to ward off intruders. The trial court corrected me to say that there was another reason in the record as to why she was going, why she had the weapon. Okay. So then I quickly dealt with, well, I wasn't trying to mislead the evidence, thinking that the judge had recalled something. But now if you look at the record, there's nothing in the record about using the rock to go on patrol as a deadly weapon. There was something on the knife only. So therefore, we get to the other issues of where I misspoke on talking about on her testimony. It wasn't her testimony. It was the testimony of other witnesses that said what she had told them. And I misspoke. That was not any, that was a negligent error on my part, which I apologized for, and I still apologize for. And it was not intended as a comment on her failure to testify. So if there was error in the closing arguments, it was mere negligence, the evidence was overwhelming, and the court should affirm the convictions. Thank you.
Any more questions?
Just one fundamental question. Does premeditation have to have any logic to it? Can it be delusional? Premeditation is to have thought the matter over beforehand. If you have a hallucination, is that sufficient?
Yes. In my opinion, that's sufficient. If you can show that it thought. And my argument here was that she thought about doing this. She had this knife. She decided that using a rock would be a better weapon. It would be over with more quickly. It's what she told Detective Wilson. So she goes into the bathroom, gets the 8-pound rock plus rock out of the shower, takes it back, and then hits him in the head. And then that didn't work. He wakes up and he says, "Mommy, stop." And she has this knife by then and is stabbing him. And he tries to put his hands in front of the knife, and his hands get cut as well. There's defensive wounds in the autopsy. And so she at least reflected on from the time that she was going to the bathroom to get the rock. Then we have some other statements that, well, she had the knife, had taken the knife back to the kitchen, and then brought the knife back in. And, you know, whether or not the knife was laying down or she still had that in her hand because she was going on patrol, but she said that she had put the knife down, pick up the rock, and struck him with the rock. And then she abandoned that idea and got the knife and stabbed him 7 times, and 3 of them are clear through his body. So she had ample opportunity to reflect, and that's why my evidence is a premeditation.
Any more questions? Thank you, counsel.
Thank you.
Justice Barr, you're asking about the special verdict question on second-degree murder, and I just want to point out there is actually statutory authority for that. The mental disease or defect used to be 21-32-20, right? And there's still several statutes around there regarding mental disease or defect that talk about notice and what happens if the jury makes the finding, and that talk about mental state. Well, if you look at 22-32-22, it says that if the jury, because of mental disease or defect, says the defendant's not guilty of the charged crime, but the jury finds the defendant guilty of a lesser included crime or another crime, then it gives a procedure that the trial court's supposed to follow, which is basically what they call discretionary commitment. So in fact, there is actually statutory authority for that second verdict question, because the judge needs to know, did the jury come back on the lesser included because of the evidence? Or did the jury come back on the lesser included because of mental disease or defect? Because if the jury comes back on the lesser on mental disease or defect, then the judge has authority to do the hospital route and send for a report and follow all that procedure.
So when the judge said we don't need that much information, the judge was incorrect.
Right. And I didn't actually pick up on that statute until just before oral argument, because it's not actually in the statute books. It's really weird. It's not in the supplements. But if you go, there's just no mention of it. But if you go to Westlaw, it's showing it as a current statute. And I think nobody cites it.
Again, counsel, I'm sorry, 21.
It's 22 dash 3222. So 3221 is a statutory authority for the first special question. which says, are you not guilty because of mental disease or defect? And then that mandates commitment. And that's the special question that's in the PIC instructions. 3222 talks about if they find guilty of a lesser included or another crime because of mental disease or defect, what the judge is supposed to do.
So let me be sure I understand. 223222 is not in the supplement or the bound volume.
It's not mentioned in the supplement. So when you sometimes, depending on the year, it'll have just the cases that are cited, but it'll still kind of mention the title. But it's not. But
That's only when there are cases to add, right? So is it in the bound volume?
21, what'd you say, 22?
Nobody cites that case. I couldn't find it cited in any case. I mean, that statute. I couldn't find it cited in any case law. But it's on Westlaw, and Westlaw is showing it as a current statute. Still in effect. It's showing 3220, it obviously got recodified into it's the old mental disease or defect, it got recodified into the other chapter. So anyway, I just want to point out there was authority for that. And I do want to point out that this was all driven by the prosecutor, not by defense counsel. Defense counsel didn't actually object to this second special question. What defense counsel objected to...
The record shows you did, counsel.
What defense counsel objected to was when the state tried to bring in an instruction. It said the only culpable mental states are intentionally, recklessly, and whatever the other one is. That's when defense counsel objected. When the judge, and I'm going to misspoke, but when the judge then said, I'm not going to give that second special jury question, that's when defense counsel did not object. Neither party objected. But the judge just decided to give it.
Counsel, at page 128, the court's just read what the two special questions will be. Ask any objection to these verdict forms.
Right.
Mr. Spencer indicates that it addresses his inconsistency concern. Court says all right, and then Brown, who's the defense lawyer, says, well, Judge, I'll object because I think we've already addressed. I don't think the questions are necessary because we've already addressed these issues in the elements instruction. Number 2 contains intentionally and premeditation. Number 3 is pretty clear. It's intentional only, no premeditation. Same goes for aggravated assault.
I thought he was objecting to, let me go do that.
The court says, I think they're required by the statute, and Brown says, okay. And the court says, so it's got to go in. That's
Okay, then I stand corrected.
22, 32, 22 is in the bound volume.
Okay, stand corrected again. So, there's that.
Any further presentation? Counsel?
No, thank you.
Any more questions? Thank you, counsel. I thank all of you for your arguments this morning. The court will take this matter under advisement.